Alright, this one starts off like a routine felony hearing. But don't blink. This isn't just about stolen property or credit cards. This is about whether someone gets prison time or a second chance. And when you hear ILC, that's intervention in lieu of conviction. Translation: treatment instead of prison. If the court believes you deserve it.
The State of Ohio versus Jason Turner. Case number is 24CR41935. Mr. Turner is present with his counsel, Andrew Brenner. The state is represented by Jenny Nicholson. We are here for a hearing on ILC.
Yes, Your Honor. Just based on the defendant's history on supervision on this case, he failed to appear for 3 ILC settings previously of this hearing at the end of last year, a year ago. It was set 3 separate times. He was given opportunities to appear at all of those and failed to do so. He has then had some additional legal trouble in the interim, and so based on all of that, we do not believe he is an appropriate candidate, but will otherwise defer.
3 missed court dates, additional charges, probation in multiple states. That is not the resume of an ideal ILC candidate. Prosecutors look at patterns, not promises. And when someone fails to appear 3 times, that screams risk. So the real question here is, can he convince the judge that this time is different?
All right, thank you. Mr. Brenner, anything on behalf of Mr. Turner?
Thank you, Your Honor. I remember Mr. Turner very well. And, he's always been extremely respectful with me. I know that he's been dealing with a lot. I think, he does want treatment. He's asking for the opportunity for treatment. He has a young daughter. As Ms. Nicholson just indicated, he has had a number of legal issues over the last year and a half or so involving multiple jurisdictions. I think there's a pending, he's on probation in Kentucky. I think there's a pending charge in Indiana as well from an old incident. He additionally served a significant amount of time in the Hamilton County Justice Center on a charge that was resolved. And so I know, at least last year, he had a difficult time finding transportation up here. He was residing in Cincinnati at the time. He now resides just across the river in Kentucky. But he is motivated to try to really turn his life around, Your Honor, and get involved with treatment, get some support so that he can get a job, find housing, do the things that he needs to do, not only to stay out of jails, but to be a father to his young daughter, who I think just turned 2. And so that's his motivation, Your Honor. We'd ask this court to give him the opportunity to engage with treatment and again, just to do what he needs to do to become a responsible member of society, which I know the court's aware he has a pretty substantial juvenile record as well. That's not really anything that he's really had the opportunity to do, so he's asking this court to give him that chance.
Thank you. Ms. Nicholson, was there a statement from the victim?
There was not. He is requesting restitution, but there is not a victim impact statement.
Okay, thank you. Mr. Turner, is there anything you want to say, sir?
Yes, sir. Well, a lot of my charges is before I came here. I was fighting cases from back then. Before I came here, like last year, I was already fighting the charges in Kentucky and Cincinnati. So my charges is mainly based off not coming to see probation. I was in probation in 3 places. I just did 7 months in the Justice Center so I could get terminated off probation in the Justice Center. And then Kentucky is, I was on probation / parole in Kentucky, and then I got sent here. So if I get it, when I'm done with here, I go back to Kentucky, and if they just gonna probably sanction me 10 days or whatever, 10 days if I get out of here. But I just want to be there for my daughter and get up out of here and do what I gotta do, because I've been in foster care my whole life.
This is where it shifts from legal facts to human reality. Foster care, jail, no stable parents. That context doesn't excuse the crimes, but it explains the cycle. Judges hear this every day. The difference is whether they believe the defendant is finally ready to break it. Do you think people really change when they become parents? Or is that just something courts hear all the time?
You do not have a place to live right now?
No, I do.
Where's that?
Cold Springs, Kentucky.
Who would that be with?
My girlfriend, my daughter,
Whose house is that? Hers or yours?
my baby mamas.
Okay. How many children do you have?
One.
So what made you think that you could just go up and start breaking windows out of vehicles and stealing items from vehicles, that you would ever, one, get away with that? And two, maybe you have plenty of times, I don't know, but two, to think there would be no consequence to that?
Sir, I was young-minded. I just came home from jail. I didn't care at the time. I wasn't thinking about me having a kid, or I wasn't with my daughter and my girl at the time. I was doing what I wanted to do. And as I got older and seeing my daughter grow up, I want to be a bigger man for her so she could see how a man's supposed to treat a female. Because I never had no parents to show me the right ways or show me this or show me that. I always been in residentials or jail or placements.
How old is your daughter?
2.
Okay. Well, you're saying the right thing, so...
Now listen carefully. The judge just laid out the fork in the road: 24 months in prison or treatment in a structured facility. That's not mercy, that's strategy. Courts use ILC when they believe supervision and structure might reduce reoffending. But here's the catch. If he messes this up, prison is still very much on the table.
That's a step forward. There have to be consequences for what you did, though. So I'm thinking, okay, you could go to prison for 24 months on this case, or we could find something that would help you achieve what you say you're looking for, and that would be treatment in a facility that permits you to focus on treatment. So that's what I'll do. I want to go over your rights with you, and then we'll proceed. You're charged with receiving stolen property and misuse of credit cards. Those are both felony 5s that carry up to 12 months in prison and a maximum fine of $2,500. Do you understand that?
Yes, sir.
You are presumed innocent of the charges. You have a right to have a trial on the matter. You're entitled to have a trial by a judge or jury of 12 people. Do you understand that?
Yes, sir.
You have a right to confront every witness who testifies against you at trial. That means your attorney can cross-examine or question those witnesses to see if there's anything favorable to you, to attack the credibility of witnesses, any discrepancies that would be beneficial for you. Do you understand that?
Yes, sir.
You have a right to have witnesses ordered to appear and testify at your request. Do you understand that?
Yes, sir.
You have the right against self-incrimination. You do not have to testify in this case. You do not have to prove anything. You do not have to offer evidence. If you choose not to testify, it will not be held against you. Do you understand that, sir?
Yes, sir.
This carries post-release control, which is supervision by the Adult Parole Authority. If you violate the terms of post-release control, the Adult Parole Authority can send you back to prison for, in this case, an additional 12 months. Do you understand that?
Yes, sir.
And that means you would be on post-release control, which is supervision by the Adult Parole Authority. If you violated their rules and they sent you back to prison, even if you serve the entire term of your 24 months, they could send you back to prison for up to 12 more months. Do you understand that?
Yes, sir.
If you're convicted of a new felony during that 2-year period of supervision, the court that has the new felony case can add whatever time remains on supervision to the sentence in the new case, meaning if you have 18 months left on supervision, they can add 18 months to that sentence. If you have less than a year remaining, they can still add a year to the sentence in the new felony. Do you understand that fully?
Yes, sir.
All right, any questions about your constitutional rights?
No, sir.
Any questions about post-release control?
No, sir.
Found this to be a knowing and voluntary waiver of constitutional rights. What is your plea to receiving stolen property, felony 5? What is your plea? Guilty or not?
This rights advisement might sound routine, but it's crucial. Once he pleads guilty under ILC, he's waiving his trial rights. No jury, no cross-examination, no fighting the evidence later. If he fails treatment, that guilty plea is already locked in. That's a massive legal gamble, freedom now, but with strings attached.
Guilty.
Guilty.
What is your plea to misuse of credit cards, felony 5?
Guilty.
I accept your plea. I find that you are eligible for treatment in lieu of conviction. Grant that request, place you under the supervision of the Warren County Probation Department for a period not to exceed 3 years, but you could get this over in a year if you fully complied. Anything from the state on supervision?
Your Honor, we are requesting restitution in the amount of $5,905.33 to Guzal Databeva. Beyond that, we will defer to probation's recommendations.
All right, thank you. Mr.
Objections to that figure.
That can be split by the co-defendants, but I don't know if they've ever found out who those were.
I don't believe anybody else was charged.
Okay.
Unfortunately, I believe that's correct, Your Honor.
Okay. Is there anything further, Mr. Brent?
Well, Your Honor, I would ask, I know the court's aware, I know we had some conversations back in chambers. My client does have some pending issues in other jurisdictions. As he indicated, I believe he needs to go down to Kentucky to report with probation there. I believe he has a pending charge in Indiana, which I believe all of that will need to be resolved before he can go to any kind of treatment. So I would ask the court to consider permitting him to do that and maybe reconsidering the ultimate order depending on what may happen in those other jurisdictions.
Well, there's a procedure for him to go and take care of those, which he has to do before he goes to STAR.
Right.
And that's anything you want to say, sir? Anything else?
I was gonna ask is when I do take the STAR, is I'm gonna be able to sign my expedition today so I could go to my other place and get it taken care of before I gotta go to STAR.
I don't know if it'll happen today, but it'll have to happen before you go there.
Yes, sir.
Okay, so order restitution in the amount of $5,905.35 as a condition of ILC. Order that he successfully complete the STAR program and any and all aftercare. I don't think you have serious. You don't have serious substance use issues other than you smoke marijuana and that's been a problem for you.
Yeah, but I haven't smoked in probably 3 years.
Okay, so there may not be much involved in that.
Yes, sir.
And there it is. Instead of 24 months behind bars, he gets treatment, probation, restitution, and a narrow path forward. But notice something. Kentucky probation, an Indiana warrant, restitution payments. This isn't a clean slate. This conditional hope.
Anything else from probation I haven't addressed?
Nothing further, Your Honor.
Anything else from the state I haven't addressed?
No, Your Honor.
Mr. Brenner?
Your Honor, I think there are 33 days jail time credit.
That is correct.
Okay, you get credit for that. Do you have any questions, sir?
The only question I got is, so when I leave here, when I'm done with this court, when I go back to the jail, is I'm done right now?
You go back to the jail and they'll have to make arrangements for Kentucky to pick you up, I believe.
So that's what I got.
And then you've got to go to
Yes, sir.
take care of that problem. You might want to let them know what happened here so they can take that into consideration. What's the charge in Indiana?
I don't know yet. I haven't even been there or got the charge yet. I just know I had a warrant when I came.
Okay. Do you have any other questions?
No, sir.
All right.